Okay, I'm going to begin the next segment by talking about explaining what a limited liability company is and how it functions and why it has become the preferred means of taking title to property for most small real estate investors in this part of the world in Texas. The authority that you can go to and find, and these days, by the way, thank you, George. Okay. One of the things that is a powerful tool is Google, and you use Google and you pull up a statute and then you can hit Control F and search for a particular keyword, and you can find things in the statute very quickly and easily by that keyword. So the thing you would ask for is the Texas Business Organizations Code in Texas statutes. You can literally on your microphone, if you've got an iPhone, just say Google Texas statutes and then look under the Texas Business Organizations Code, and you'll find out how this statute is organized, etc. A limited liability company is incredibly flexible in its management. It's a lot more informal than a corporation. It is effective at providing a liability shield for its owners, which are known as members, and for its directors, which are known as managers, and for its employees. And the assets are separate from the members' interests, which essentially means that you can't reach the assets of the LLC, and the creditor is typically limited to getting a charging order as a remedy to trying to collect the debt against the member. Now, if they've got a claim against the LLC, contractual claim or otherwise, and they can reach the assets in the LLC. But the liabilities of the LLC can't typically reach the assets of the member, and the member's liabilities the assets in the LLC can't be reached by creditors of the member. So that's a powerful estate preservation planning tool. Then the federal income taxation options include pass-through taxation, and that's one of the very nice possibilities. You can have the entity disregarded as a separate tax-paying entity and just have the member and his or her Social Security number report the income of the LLC. Now, the other thing that's nice that's different from a limited partnership is the members can participate in the management without losing their limited liability status. So that's very important, but that doesn't mean that the members can engage in fraud or negligence themselves, as I've indicated in previous segments. The LLCs are treated as a separate legal entity for contract and tort purposes. That's what we're trying to do. And generally, members' assets may not be attached for an LLC debt, whether in tort or in contract. The protection of the personal assets wouldn't apply if the member guarantees a debt or commits an intentional tort, and a judgment creditor, as in limited partnerships, is generally limited to a charging order against the member's interests, which means they're going to have to sit and wait until there is some kind of a distribution made to the member of the LLC. Now, under a charging order, the distributions that are attributable to a member will instead be made to the judgment creditor who gets a charging order, but judgment creditor usually has no right to compel distributions or demand that the membership interest be liquidated or to participate in the management or operation of the LLC. And the judgment creditor, when he gets a charging order, becomes an assignee of the member's interest, and therefore he is subject to the income tax on the pro rata share of the LLC's income, whether it's distributed or not. So it's a dangerous process to get a charging order, but at the same time, it's essentially the only remedy that you've got as a creditor. The manager of the LLC controls the timing of the distributions, making the attachment of a member's interest through a charging order less attractive to the judgment creditor, who may wind up paying substantial income taxes on an asset that hadn't been actually received. Now, there are courts in other states which have allowed judgment creditors to reach the property that is held by a single member LLC, and there's a chance that Texas courts may decide to follow the lead of those court decisions in other states. the duties of a manager, or if it's the members who are managing, the duties of the members are generally assumed to be fiduciary in nature, and that's similar to the fiduciary duties of corporate directors, which means they have to put the interests of the entity and the other owners ahead of their own interest. But it allows the LLC statute allows company agreements to expand or restrict the duties, including fiduciary duties, and the liabilities of members, managers, officers, and other persons affiliated with the LLC. Now, the LLC is formed when you file a certificate of formation. It's filed and accepted by the Texas Secretary of State. There's a $300 fee. Now, I put an asterisk there because if you send it in by mail and you want it expedited, it's $325. If you use a credit card, it's $308.10. Certificate of formation's got to state whether the LLC is going to be manager or member managed. I generally recommend to my clients that it be manager managed. Nobody then will have a public record to determine who the members are. You can set forth the names of each initial manager, but if it is member managed, then you set forth the names of each initial member. And the LLC must use one of the following in its name. I like the term LLC because that's more clearly understood as what it is, and it's short and easy. I don't like periods. I prefer just it to say LLC without periods. The LLCs have a perpetual life. That wasn't the original concept, but now it is very flexible as to the transferability of the interest, and they can't be publicly traded. So that's one of the limitations on using an LLC instead of a corporation if you're trying to raise a lot of equity capital. And there's a good argument that attorney's fees cannot be collected against an LLC. And the reason for that is that our attorney fees statute talks about having the right in a contract to recover attorney's fees from a corporation or from an individual, and the word LLC is not included in that statute. Don't have any court cases, but that's the argument that would be made. Now, I'm going to compare an LLC with a corporation because I think it helps to explain how it functions. And an LLC is owned by members, just like a corporation is owned by shareholders. An LLC is managed by its manager, just like a corporation is managed by its directors, typically. It's formed, both of them are formed by filing a certificate of formation. That's a relatively new change since 2006. One of the things that's important to realize is corporations used to be formed by something called articles of incorporation, and LLCs used to be formed by something called articles of organization. So if you've got something before 2006, it may call it that document instead of a certificate of formation. If you're talking to an attorney or you're looking at something online and they're still talking about articles of organization or articles of incorporation, then they're not up to date with how we term this organizational document in Texas since 2006. Now, an LLC is governed by something called a company agreement, and a corporation is governed by something called bylaws. Before this 2006 amendment to the Texas Business Organizations Code, we used to refer to the company agreement as something we called an operating agreement. And if you look further back, the original concept was called regulations. I think this is a pretty easy one. In Texas, if we originally called the governing document of an LLC regulations, that was so easily confused with what we think of it normally as regulations being issued by and enforced by the government. And that's not what this was all about. This was a private agreement as to how the LLC would be governed. So they decided to not continue using the word regulations. That word is still used in other states. So we changed the name and we started calling it an operating agreement. And that ended up being confusing in Texas because that's a contract usually between the mineral estate and the company that's going to come in and dig a well or mine the interest, the mineral interest, and that operating agreement could be a confusing term. So now we use the term company agreement. Other states will refer to this governance document as an operating agreement, and very, very few will still call it regulations. Now, an LLC has no limit on the number of members. It doesn't have any limit on the type of members. So this is better in that respect than a S corporation. The C corporation has no limit on the number of shareholders and no limit on the kind of shareholders, but the S corporation is limited to 100, and that can be relaxed when involving family members with a common ancestry. And the shareholders are generally limited to individuals in an S corporation and doesn't include corporations and limited liability companies, etc. So it's generally going to be limited to individuals, U.S. citizens, permanent residents. Excuse me. So LLC, this no limitation on the number of members and the type of members is one of the reasons it's become a lot more popular. The history of the LLC, I think, is important because it gives you an insight into what we're going to talk about next, which is a series LLC. LLC was formed originally, the very first one was authorized in Wyoming in 1977, but by 14 years later, Texas was only one of 6 states to adopt a company's LLC statute. Then the IRS didn't determine the tax treatment until 1996 and arguably until 2001. But by the end of 1996, when the IRS originally initiated its first indication of what the tax treatment would be, all 50 states in the District of Columbia had enacted their own LLC statute. So this tells you the primary reason that people weren't using or enacting LLC statutes was because there wasn't any clear understanding as to how the IRS was going to tax them. The original limited liability company was moved into the Texas Business Organizations Code effective as of January 1, 2006 and applies to all new Texas LLCs formed since then. The Uniform Limited Liability Act was passed in 2006. That's an act that was an attempt by the Bar Association, the American Bar Association, to pick the best attributes of limited liability company statutes in the 50 states, and it's not necessarily well, the Uniform Limited Liability Act that was passed in 2006, in many instances that act is now incorporated into the state statutes, which is a fairly typical pattern. Each state does its own thing, then a committee comes along and comes up with a uniform act, and then all the states pass the uniform act. Initially, as you can imagine, lawyers didn't want to recommend LLCs because they knew what they were doing with limited partnerships and S corporations, and they were pass-through entities. They didn't know how they were going to be taxed. Since then, however, since 2000 and since the tax treatment's become much more clear, now lots and lots of lawyers would prefer using an LLC over a limited partnership, which is expensive to form. You got to have 2 entities. You got one filing fee of $750 and another filing fee of $308.10. And of course, the S corporation is limited to the kind of shareholders that it can have and the number of shareholders. So the long and the short of it is the LLC appears to be preferred essentially since the Uniform Act, and you see lots and lots of lawyers recommending it now. They are typically preferred for closely held and sometimes not so closely held businesses and investment purposes in the United States. Now, the series LLC is a completely different animal, and it's a confusing concept because of the terms that are used. A series LLC is likened, in my mind, to a parent company, a parent LLC. Delaware became the first state to authorize a series LLC back in 1996. 7 states, Illinois, Iowa, Nevada, Oklahoma, Tennessee, Texas, and Utah, then came along with their statutes. Now, there are some other statutes that make reference to series entities, but they don't provide the same level of detail and protection that these other state statutes do. And I'm borrowing this information from an article from Stephen Phillips and Cindy Grossman. They were nice enough to allow me to attribute some of this research to them. The 81st Texas Legislature in 2009 established the series LLC, and That was in May of 2009. It's under subchapter M of our Texas Business Organizations Code, and it became effective September 1 of 2009. And it differs in some important respects from the law of other jurisdictions. So the description of any Texas Series LLC law cannot be assumed to necessarily reflect the law of any other jurisdiction because the statute